Something unprecedented just happened. For the first time in decades, the ATF is proposing a rule change that actually loosens gun restrictions instead of tightening them. Yes, you heard that right. The agency known for creating more barriers is now suggesting we remove some. This affects thousands of gun owners who've been denied their rights, and the public comment period is open right now. Let me break down exactly what's changing and why this matters. The Bureau of Alcohol, Tobacco, Firearms, and Explosives just filed a proposed rule modification that's now available for public input. This represents a significant shift from the agency's historical pattern of expanding restrictions rather than reducing them. Let's establish some context first. Since 1972, this federal agency has been interpreting statutes in ways that directly impact Second Amendment rights. Some interpretations have been more restrictive than others, but the general trajectory has consistently moved toward greater limitations rather than fewer. Many gun owners remember various attempts at new restrictions over the years. There was a proposed measure roughly a decade ago that would have effectively prohibited a popular type of ammunition. Fortunately, that particular proposal was stopped through public opposition and advocacy efforts. The current proposal represents a notable departure from that pattern. While it's certainly not perfect and doesn't address all concerns, any movement toward reducing barriers rather than creating new ones deserves attention and analysis. Here's what the proposed modification addresses. The agency wants to revise how it defines someone as an unlawful or addicted user of controlled substances. This definition has direct consequences when people complete federal firearms transaction paperwork.
When filling out the required federal form during a firearm purchase, individuals must answer questions about
substance use. Those who answer honestly about past use face immediate denial of their Second Amendment rights. The existing interpretation has been extremely broad in who it categorizes as a prohibited person. According to agency data from 2025, more than 9,000 people were prevented from exercising their rights due to substance-related issues. Some self-reported their status on the form, while others were identified through testing, investigations, or previous arrests. What's particularly striking is that over 4,000 of these denials involved single incidents. These weren't cases of ongoing, regular, or habitual use. They were one-time occurrences that nonetheless triggered prohibition under current interpretations. The existing framework is quite restrictive in practice.
People who may have experimented with something on a single occasion
years ago could find themselves categorized as prohibited persons if they answer the form honestly. This creates a significant gap between the stated purpose of the law and its actual application. Courts have generally interpreted these provisions to apply to people who currently, frequently, or habitually use controlled substances. That's the general judicial interpretation that's emerged through various cases over the years. However, the way the federal transaction form has been administered doesn't align with that judicial standard. For example, a single positive test result within the past 12 months has been sufficient grounds for denial through the background check system, regardless of whether that represented habitual use. This disconnect between legal precedent and administrative enforcement created an inconsistency that needed addressing. The new proposal aims to bring the administrative interpretation more in line with what courts have actually said the law means. The proposed modification includes several specific changes to enforcement under the relevant federal statute. Here are the key adjustments being considered.
First, they want to eliminate the consideration of a single conviction for use within the past year as grounds for prohibition. A one-time incident from months ago wouldn't automatically disqualify someone under the revised framework. Second, they're proposing to remove a single positive test within the last 12 months as automatic grounds for denial. Again, this addresses situations where someone isn't a regular user but had one instance that currently triggers prohibition. According to the proposal language, someone would not be considered an unlawful user if their use was isolated or sporadic. Additionally, if someone has discontinued regular unlawful use, they would no longer fall under the prohibition. The proposal also addresses prescription medications. Currently, there's ambiguity around lawful prescriptions for controlled substances. The new framework states that minor, immaterial deviations from lawful prescriptions
There's also
don't
a
convert
significant
someone
clarification
into an
regarding
unlawful
medical
user
marijuana.
category. There's also a significant clarification regarding medical marijuana. In jurisdictions where it's legal with a prescription, users with valid prescriptions would not be categorized as prohibited persons. The proposal explicitly states that someone using a controlled substance with a valid prescription, regardless of the substance's classification schedule, is not considered an unlawful user. Instead of the current broad approach, the agency wants to require proof of recent, regular, and habitual use before classifying someone as prohibited. This represents a much higher bar than what currently exists. Under the proposed framework, if someone doesn't meet these stricter criteria for what constitutes a user, they would be able to answer no to the relevant question on the federal form. This could restore rights to thousands of people currently prohibited under the broader interpretation. The public comment period for this proposal extends until June 30th of this year. There are specific deadlines depending on how you choose to submit feedback. If you prefer submitting comments through postal mail, your submission must be postmarked by June 30th to be considered. Electronic submissions have their own timeline considerations. For those on the West Coast, it's important to note that the comment period closes at midnight Eastern Standard Time. Make sure to account for the time zone difference when planning your submission. This proposal went through dozens of pages of detailed regulatory language. The document is quite extensive and covers various scenarios and edge cases that might arise under the new framework. Based on careful review of the proposal text, this does appear to be a genuine attempt to ease restrictions rather than create new ones. That alone makes it noteworthy, given the historical pattern of regulatory expansion in this area. To be clear, this doesn't address all the concerns many people have about firearms regulations. There are numerous other rules and interpretations that arguably exceed constitutional boundaries or statutory authority. Much work remains to be done on those fronts. However, progress doesn't always come in sweeping changes. Sometimes it comes incrementally. When movement occurs in the right direction, even if it's not as far as we'd like, it deserves recognition. The fact that this proposal exists at all represents a shift in approach. For years, the regulatory trend has been consistently toward more restrictions, more prohibitions, and broader interpretations that capture more people under various prohibitions. This proposal moves in the opposite direction. It narrows who falls under prohibition. It aligns administrative practice with judicial interpretation. It recognizes that a single instance of use years ago instance of use years ago should you necessarily result in permanent loss of
thousands of people currently denied because of single incidents or non-habitual use. This could restore their ability to exercise Second Amendment rights. That's not an abstract policy debate. It's real people who've been prevented from defending themselves and their families. The prescription medication clarification also matters significantly. As medical marijuana becomes legal in more jurisdictions, the conflict between state law and federal prohibition has created confusion and trapped lawful state residents in federal prohibitions. Now, it's important to participate in the comment process. Regulatory agencies are required to consider public input before finalizing rules. Substantive analysis, personal experiences, or legal arguments carry more weight than simple statements of support or opposition. If this proposal affects you personally, sharing your story could be valuable. If you have legal or constitutional arguments about why these changes are appropriate submitting those thoughts helps create a record. If you work in the firearms industry and have seen how the current interpretation affects customers, that perspective provides useful context for decision-makers reviewing the proposal. The comment period exists for a reason. It's an opportunity for affected parties and interested members
opportunity
the
for
public
affected
to
parties and
provide
interested
input
members of the
before
public
a
to
final
provide
decision
input
is
before a
made.
final decision
Taking
is made.
advantage of that opportunity
Taking advantage of
ensures
that
your voice is
opportunity
heard in the
ensures your
process.
voice is heard in the process.
Looking at the bigger picture,
Looking at the
this
bigger
proposal
picture,
could
this
signal a
proposal
shift
could
in
signal a
regulatory
shift in
philosophy.
regulatory
If
philosophy.
finalized,
If
it would
finalized,
demonstrate
it would
that
demonstrate
easing
that easing
restrictions is
restrictions
possible, not just expanding them. That precedent could be valuable for future reform efforts. The ATF's proposed rule change represents an unusual but welcome development. A federal agency proposing to loosen rather than tighten gun restrictions. By aligning the definition of prohibited users with actual court interpretations and requiring proof of habitual use rather than single incidents, this could restore rights to thousands of Americans. The public comment period runs until June 30th, and participation in that process could help ensure these changes become reality. While much more work remains on firearms policy reform, this represents a step in the right direction.